Now, a few things I want to point out for you to look for before we dive into this order. Um, and I call it torturous, and it really is. They torture the law, they torture reason, they torture the English language. They clearly are determined to arrive at this outcome, no matter what obstacles of law, reason, and language may lay in their way. And there's a lot of little tricks here that you learn to look for when you're an attorney. One is there's lots of obscure citations to other cases. Why is that a red flag? Well, because of course there's who knows, hundreds of thousands of cases out there. And if you can pluck out a handful of words from a case that appear to support your position, knowing that no one's going to go look at the case, well, then you're engaged in deception. You're engaged in misinformation, because what the words appear to mean may not be what they mean. They may be applying to a different legal doctrine. They may be mere dicta. They could be just nonsense, completely out of context with the particular argument being labeled here. And the more of those obscure references to other cases I see, the more it smells to me like that's exactly what these judges are doing. That if I were to go look at the 300 odd cases they cite to in these 50 pages of their order, that a lot of them would be clearly distinguishable from the argument they're making in this paper. But they're relying on us not going to look. Another red flag is every time you see a cite from these people, these judges, that is full of ellipses. Ellipsi, what's the plural of ellipsis? Those are the ... dots. So you see a word, ... You see a few more words, ... You see a few more words. Those dots are representative of words that have been taken out of the quote. Why were they taken out? Well, sometimes it's appropriate to do that. Sometimes you're just trying to clean up the language while staying true to its original intent. Sometimes you're taking words out that matter. Sometimes you're taking out words that completely change the intended meaning of the phrase you're quoting. So that is also a huge red flag. I see a bunch of here. There's a lot of...
Did you know that in all 50 states, self-defense law, not gun law, but self-defense law, uses a simple 5-element test to see if your use of defensive force was legally justified? And that same test applies no matter what state you're in or what tool you use to defend yourself. If you're missing even one of those required elements, however, you've made yourself an easy conviction for an aggressive prosecutor. My name is Attorney Andrew Branca, and I've worked more than 30 years as a self-defense attorney. Every state has seemingly endless, complex pages of laws regarding self-defense, so complex that many top criminal defense attorneys rely on my expert analysis to help win self-defense cases for their clients. If the legal code is that complex for lawyers, how can a citizen gun owner expect to know or even follow the law, especially when a life or death situation has triggered a massive adrenaline-fueled mandate to make that fight or flight decision right now? It seems daunting. Yet I created a simple but powerful framework that has allowed me to serve the legal community and countless American gun owners to simplify this legal complexity into just 5 elements of self-defense law. And you can learn my 5-element legal algorithm I use to consult on and win with the top criminal defense attorneys all over the country to protect law-abiding gun-owning citizens from making innocent legal missteps that land them in prison. Now, with a simple read or listen, you can install my 5-point legal framework so it acts as a sort of muscle memory defense to protect you from losing your rights when you choose to defend innocent human life. Click below to get the latest edition of my book, The Law of Self-Defense Principles, for free. I ask only that you help cover the shipping and handling cost to get the book to you.
Inversion happening here. So the entire history of tariffs in America is Congress delegating that power to the executive and the courts giving the executive enormous discretion in the exercise of that delegated power. If there's any ambiguity about whether the executive's use of that tariff power is permissible or not, the courts invariably presume that it is lawful. It's only in the most egregious cases that the courts have held that a application of delegated tariffs by the executive is legally unsound. These judges do the opposite. These judges look for every weaselly opportunity to try to argue that the president doesn't have the discretion he's always had in American tariff history. Everything has to be narrowly defined against the efforts of this president, when in every other tariff case in history, the reverse was true. Every effort, the courts would bend over backwards to find the executive's exercise of the tariff authority delegated by Congress to be lawful, until yesterday's order by this Court of International Trade, where they're bending over backwards to make every effort to find Trump's application of this delegated tariff authority to be unlawful. It's a complete inversion of the norm. There are other red flags too. We'll see, and I'll mention them as we get to them. But let's start diving in to this tortured opinion. By the way, these are the three judges. You'll hear a lot of people saying one was appointed by Trump, one was appointed by, I think, Obama, one was appointed by Reagan. The Reagan appointee is almost 80 years old. Does anybody think judges are doing their best work at 80? 77 years old. And keep in mind, just because someone is a Trump-nominated judge, nobody knows how these judges are going to work out in the long run, including Trump. It's just like hiring employees. You don't really know if that new employee is going to work out. The real check on bad employees is not in the hiring process, it's in the firing process. But of course, among federal judges, we effectively have no firing process, as attested to by the 77-year-old Reagan-appointed judge here. Let's see. Another issue here is, again, we have one of these federal courts not issuing just a temporary restraining order or a preliminary injunction as we go to trial and argue out the case on the merits. We have another one of these federal judges, three-judge panel here, simply saying Trump loses. Trump loses. It's summary judgment. It's so obvious that Trump loses that we don't even need a trial. So summary judgment against Trump on this tariff question. We just saw last week the Supreme Court itself reversing a summary judgment against Trump in a firing case over Gwynne Wilcox of the National Labor Relations Board. That judge, too, said, summary judgment, it's so obvious that Trump loses, we don't even need a trial on this case. Reverse 6-3 by the Supreme Court. Obviously, it wasn't all that clear that Trump ought to lose, because he ended up winning, didn't he, Judge? So another summary judgment case here.
Thanks for watching this highlight segment of our full-length Law of Self-Defense live stream. If you enjoyed this content, make sure to give us a like and subscribe for more expert analysis on politics, law, and how to be hard to convict. And to watch the full-length episode of this show, just click right here. Stay safe.